Now you say you have some independents who are supporting.
There's already supporting,
right? There are some independents who are supporting.
Both sides had independent supporting it. We had 11 supporting.
One second, Nagal.
1 second. We're trying to look. These examples are only to see what the governor should in a situation. We are just giving.
Well, then how? Well, it is not just what did he apply his mind to this issue. Well, this is all very well. We are happening in a court of law. But did he apply his mind to this issue?
But Mr. Sibal, one thing which we cannot therefore discount, the governor has two responsibilities. One, the governor cannot enter into the thicket of disqualification. Two, the governor cannot do anything which seems to protect those who have incurred the wrath of disqualification. There we are with you completely. Equally, what is of concern to us is that the governor, in all these political wranglings and whatever goes on in the polity, there is a very high constitutional principle, which is that whoever is sworn in as the chief minister must ultimately have accountability to parliament and therefore to the people. Otherwise, what we'll be doing is that the defections have two consequences. The defectors have a personal consequence that they get out of the house, that their seats become vacant. But equally, we cannot gloss over the fact that the defection affects the stability of the government itself. And how does the governor, as the head of the state, ignore the consequence of...
Where is that question that arises here, Manoj? Where is that question, please? How does it arise here? How did the governor didn't look at all this, what your lordship were putting to me? Ask for the records. So, Manoj, why go into a hypothetical situation, Manoj? With the greatest respect, Manoj, your lordships have so much experience. Let's not tread into areas which we are not called upon to tread upon. We are here as to how 39 or whatever 34 go to the governor, and the governor recognizes the 34, knowing that they are in the Shiv Sena. There is the leader of the Shiv Sena. They recognizes Uddhav Thackerey. He recognizes the split and administer the oath of office. How does all this enter into this into the reckoning here?
As a principle, you are saying that the governor could not have got into it, has not got into it.
Yes,
number one.
Yes, has not. Yes.
And the premise for that is that the governor cannot do it constitutionally.
That's right.
It should not.
That's all that your lordship is to consider. And I can understand, Manoj. I can understand the situation. There can be another hypothetical. I'm sorry.
So once there is an existing government, according to you,
Yes.
which this was not a government formation for the first time.
That's correct.
Then the governor, short of a no confidence vote which is brought on the floor of the house,
Yes.
the governor must ensure that the existing position continues until somebody brings a no confidence vote.
That's the only way. Now your lordships have laid that down. No longer parading, no longer comparing signatures, all that is over. So if the BJP thought that we had lost confidence, they should have moved a motion.
That is because of Bommai, which said that it's only the floor of the house.
That's correct. So you move a no confidence. How do these issues come in at all? There's no discretion.
So according to you, as a matter of principle, absent a motion of no confidence,
That's right.
The governor must continue with the existing position.
That's correct, because there's an elected government.
Right.
Now this is much worse, that he recognizes the split and administers the oath of office.
And thereafter the floor test was subsequently.
Yes.
That is
On 4th.
Yes, on 4th.
3rd or 4th.
Including those 39.
But there, so far speaking for myself, can the governor, correct? Because under the 10th schedule, it is for the speaker to take a decision.
Right.
Correct? Can the governor, correct, on his own, without any disqualification, the speaker can take cognizance that they are disqualified?
Your lordship is right, absolutely right, but they are still the Shiv Sena. That question will still have to be answered. What is that? What are the 39? They are still the Shiv Sena. So then he recognizes the split. That's the problem. That's why the 10th schedule, that's why the whole paragraph, this is the issue. When 3 was eliminated, it was only for the purposes, deleted, it is only for the purposes, majority or minority, you can't destabilize an elected government. And constitutional morality was the linchpin. So let's say, and that's why I told your lordships, ideally the governor should have said, no further action, get your disqualification decided, then I will see. I told that to your lordships earlier.
But suppose the speaker doesn't decide.
Listen.
Suppose these qualification questions are not decided at all. In the meantime, the governor is satisfied. Correct? He on the basis of the material
he
correct?
Can't. Well, that's not his job. It's the no confidence motion in the House. How is the government satisfaction after election doesn't arise? Well, I'm sorry. As a constitutional principle, it doesn't arise. Don't give that discretion to the governor. You will have toppling governments every other day. First the ED will go, then the CBI will go, then the governor will exercise discretion and governments will be toppled. How's the discretion?
So Speaker versus Governor. Speaker versus Governor, as I had said. So the flip side of it is that without any chance for all that to be panned out, the Speaker shows over anxiety to take up the matter and immediately disqualify all those who are intending to...
Well, the Speaker should decide. Your Lordships have now said within 3 months. This is the judgment of this court. That within 3 months, Speaker must decide. Normally earlier, but latest within 3 months. Justice Nariman's judgment was
No, I was telling you about the flip side of it. Is on the one hand, yes, governors over anxiety saying that, okay, you prove the majority.
Right.
On the other hand, we have a speaker exercising that discretion and says, now come on, you immediately show, I will disqualify all of you. So these are the two constitutional
parties. One is subject to judicial review, the other is not. Difference is one is subject to judicial review, the other is not.
All are subject to judicial review.
No, but once a new government is formed, if he calls for a trust, new government is formed, what judicial review?
True. Remedy is a different matter. I agree with you that there is a remedy.
Yeah.
But really speaking, it's there. What we need to interpret is the scope of the jurisdiction of the governor and the scope of the jurisdiction of the speaker also.
The speaker, of course, the scope of jurisdiction is clear. He has to decide the matter.
To open extent.
He has to decide the matter. Now, it's not just can't come to pay.
I'm not saying anything right now, but factually,
Please.
yes, all right. Factually, made an incorrect statement, and there was no input given to the governor. There were 2 letters sent to the governor, which the governor has referred to in a letter to Mr. Uddhav Thackeray before he called for a floor test.
Correct, absolutely.
So that there is enough material for the governor to decide that this government was...
I think my learned friends...
have to ask the other side. What was the material before the governor on the basis of which asked Mr. Shinde to form the government?
Well, that's...
Particularly when he knew that this was really a breakaway faction.
Yes, how does he justify that? The question is, how do you administer an oath of office to Eknath Shinde? Now, I can understand. There's another situation. There are multi-parties, not just in this case. There's in several states, we have a multi-party system. Several parties come together, and suddenly a no confidence is moved. Or somebody seeks, and in the meantime, some disqualification petitions are pending. At that stage, the governor doesn't bother about the disqualification petitions. There's a no confidence. These fellows will vote. Can you see, the consequences? We'll take the 39 to be validly members of the House, not disqualified. Disqualification petitions pending. Move a no confidence motion. Now they can't move a no confidence motion because the 39 will be subject to the whip. So they know that they don't have majority. Therefore, what do? 39 go to the governor and say that now recognize me. So please appreciate, the way to ensure that the government falls is to move the no confidence. Why did they not move it? They could have, the 39 could have voted, they are members of the legislature. They did not move it because they knew that they are part of the Shiv Sena, subject to the whip. The government will sustain, will not fall. So the only way out was this conspiracy. And that was hatched much earlier. That's how they went to Gujarat and Assam. Having done that, they wrote that letter which I read to your Lordships, I've read that letter that, this present government, the party members are very unhappy with it. We have been not following the ideology of Bala Sahib. All that letter I read to your Lordships, and then they go to the Speaker. So whether it's majority, minority, it really doesn't matter, So how could the trust vote be called? Trust vote means that you have prima facie lost confidence. Governor knows That this government is not why we go into the matter, Manas, that the governor will presume that these people will be disqualified. Why do we even presume that? They are qualified till such time as they are disqualified. So move on, no confidence. So Manas, your Lordship must ask the question, why they didn't do that? And Manas, let me put it this way. If they were so concerned, Manas, they should have voted against the whip. They should have voted against the whip. Now, your Lordships have seen the correspondence 21st June onwards. There is not a whisper of any rival group. Not a whisper. It's only the 39 sitting there.
So, just to rephrase it, according to you, there was no information in the possession of the EC to show that there are rival groups, and it has to be satisfied.
Yes. Now, Maharaj, the petition.
Can you just rephrase your submission, Mr. Sibal, again on this point?
Maharaj, saying Maharaj, the jurisdiction of the commission will commence when the commission has in its possession information on which it is satisfied that there are two rival factions within a political party.
Right. And in this case, what is the...
Now let's kindly see. Therefore, in the context of this 10th schedule, Maharaj, now just that proposition. In the context of the 10th schedule, the only way you can get a symbol is when there are two rival factions within the party. It has nothing to do with the 10th schedule.
No, this has nothing to do with the 10th schedule. Correct.
Right. So, Maharaj, there has to be a faction emerging. Take, for example, Maharaj, majority of the people in the 10th schedule are with Thackerey. Let's assume all 55 are with Thackerey. Then also para 15 can be invoked
by somebody making an application.
Because 15 para 15 refers to the party.
That's right. So one of the split
refers to
correct. The split has to take,
I'm
agreeing. I'm saying exactly right. That split has to take place within the party.
Right.
That split did not take place on 21st June or immediately thereafter. Never took place. A petition is filed on the 19th of July.
Correct. 19th of July.
Just note that, Manoj.
19th of July.
19th of July.
19th of July, absolutely.
Correct.
Right.
And on the 18th of July, it is alleged, what is submitted along with the petition is minutes of meetings.
Where are the minutes of meeting here in this compilation page, PDF page?
Yes, we've just shown that one. Here and it's not there. That's why
it's not an annexure.
That's why I gave that to your Lordship.
It's a symbol, but that's not an annexure to the petition. Are we right?
It's not here, Manoj. That's why I gave your Lordship.
No.
Where are those minutes?
I'm just let me hear my.
What you have read of this para 26, para 25 refers to annexure P5, which is the minutes of the meeting of the.
We haven't put it, Manoj. That's minutes.
We don't have, but the petition also does it and close it is what we are trying to understand.
Yes. That was handed over, Manoj. It doesn't say. That's why we gave it to your Lordship.
That is what the 27th.
So now it says 27th. This petition is filed on 29th. These are. They did enclose the second one. They didn't enclose. First one they didn't enclose. P5 they enclosed. So, Manoj, these are the two documents with the commission. Now, if you read paragraph 15, this represents two factions in the party. The minutes of meeting. That's how the election commission, Manoj, got jurisdiction according to them. And Manoj, this is a final order. This is kindly just look at it. I can understand if the commission says lead evidence. I can understand, please prove your case. On this basis, a final order is passed, which is the subject matter of challenge in the other proceeding. That's how they got the symbol. So, what does the governor do? What does the election commission do? And this is the evidence. And then we have to, we must ensure, we must trust that all institutional authorities function in accordance with the law. And if this kind of manipulation takes place, Manoj, in the processes of institutional decision making, where we go, Manoj, where we will go, I don't know. This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Manoj? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows because the disqualification petition is pending, Malas. He also knows it. And if the governor does, Malas, swear him in as a chief minister, Malas, he actually topples a democratically elected government and aids in doing that because they happen to be majority in the legislature. Well, that's one of the issues that your lordship may have to consider. The other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Malas, place before your lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10th schedule?
That's correct.
10th schedule.
Yeah, that's correct. That's correct. That's correct. Because under the 10th schedule, it has the speaker to decide, Malas. But if the proceedings, Malas, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter?